there was a tremendous amount of pressure that there should be more reporting. Well, the child welfare system is already drinking from a fire hose. They get 3 million reports a year, 5 million children, and at the end of the day, only about 28% of those reports were investigated. Their resources have been used up, and they're exhausted by the investigatory process. So they don't have much left to offer to the 700,000 or 800,000 cases that are substantiated. So you didn't want to revise the law to turn up the volume of the fire hose. Then there was one other nuance in the law that we debated a lot at the Field Center, which was chain of command in schools. Well, by the time it gets reported, if it gets reported, it's quite distant from the person who has the most important knowledge. In the Sandusky case, one of the key points in that case that's going to come back again and again and again is, what did Mike McQuarrie know? Because by the time the case got to the president of Penn State, it was very muddled.
So rewriting the definition of abuse was something that was really critical. I'm so pleased to see that the task force recommended taking out the subjective nature of the current law. To look at serious physical injury in the current law, the child had to, quote, experience severe pain. Well, that's something, number one, that's very subjective. It excludes children with developmental disabilities or preverbal children. And, indeed, it makes it a situation where the victim has to diagnose themselves. That's really not the purpose. The child abuse reporting statute should serve as a guidepost and guideline for a caseworker to investigate a case. Yet in Pennsylvania, the law is so unclear that county to county to county, we're all handled differently, and that's wrong.